Good afternoon, Elkhart. Thank you for having me today. I appreciate being able to talk to you all and give you a legal update. I understand this is your first meeting back in person for some of you, so I wish I could see you all in the room. I see some of you are here via Zoom and some are there in person. So hopefully you'll be able to hear me just fine. I've been asked to talk about a few different things. First of all, I wanted to start out with love letters. I understand that your education committee provided some sample letters for you to look at. So first of all, you know, what is a love letter and why are they used? A love letter can also be called a personal information letter, or as we like to call them, a liability letter, because you could get into fair housing trouble. So why are they used? They're used by buyers to stand out to a seller in a highly competitive market as it is right now. So although they appear to be harmless, the information contained in these letters can create fair housing risks, as they may reveal the race, the religion, the familial status, the disability, and so on of that buyer. The information could then be used by the seller to unlawfully then accept or reject an offer. So that's the concern. So what do fair housing laws require? Fair housing laws require selling real estate to anyone who is qualified, regardless of an individual's inclusion in any protected class, such as race, religion, familial status. So while it's one thing for a buyer love letter to tell a seller how much they like a property because of the location, the characteristics, the style of the home, the letters often get much more personal and include statements such as, I can see our children celebrating Christmas here. My wife and I would love to raise our family in this house. Or I finally found a home that can accommodate my wheelchair. Or we're so excited to send our children to the Catholic school down the street. So as you can see, there's a lot of personal information. There could be photographs also provided with these letters. There's a nationwide concern that there could be fair housing risk with these letters, as well as a violation of Article 10 of the Realtor Code of Ethics. So the Article 10 in the code says realtors shall not deny equal professional services to any person for reasons of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Realtors shall not be parties to any plan or agreement to discriminate against a person on the basis of race, color, religion, sex, all the protected classes that I just mentioned. So as a real estate professional, be aware of the potential danger and liability with these letters, discourage buyers from writing the letters, discourage sellers from accepting the letters. Buyer agents, raise these fair housing concerns with your buyer clients up front so that they don't draft them to begin with. Listing agents, discuss the potential liability during the listing interview and get that seller's permission, if possible, to not accept or deliver these letters if one is provided. Another way to deal with this also is in the MLS. You could put in agent remarks that the seller will not accept personal information letters. Now, again, this has to be with the seller's permission, obviously, so you want to make sure that the seller does authorize you to prevent the delivery of these letters. Sellers who do accept love letters should be prepared to demonstrate a non-discriminatory reason for accepting that buyer, especially where that buyer did not present the highest offer. So a question we get fairly frequently is well, are these part of the offer? And the answer, of course, a completely legal answer, it depends. Love letters and personal pictures are generally not part of the purchase agreement and will likely not be provided to a lender or a title company if that offer is accepted and fully executed. As a listing agent, however, you can't withhold that letter if it is part of the offer without the seller's permission. Otherwise, you're violating Indiana license law and the Code of Ethics by not delivering all offers to the seller objectively and quickly, as required by both those areas. So remind your clients, the decision to accept or reject an offer really should be based on objective criteria only. A seller's decision should be based on the price, the terms, the ability to close, not on emotional reasons. If the seller instructs the listing agent to withhold these personal information letters and any pictures, there's then no violation by any of you realtors of legal or ethical duties to submit all offers, and it could and will prevent future fair housing claims in this regard. So sellers, listing agents, consult with your sellers up front, get their permission to not deal with these letters. Buyers the same, and hopefully you will not have any issues with down the road with these love letters being provided. We do have one example in Indiana. I have not seen any fair housing claims filed in Indiana due to love letters at this point. But I was advised that a seller here in Indiana accepted an offer that was $15,000 less than the best offer because the buyer submitted a letter indicating she was a single mother. They empathized with the buyer and they took the inferior offer, which is admirable, but could be a violation of the Fair Housing Act. For example, picture if the higher offer was from an American family, then there could be an allegation or a potential violation of a fair housing claim for the rejection of that higher offer. So just to give you an example there of why and how these letters can create liability. Okay, this is a good time to segue to the fair housing expansion in the Realtor Code of Ethics. I do want everyone to know that fair housing laws, national, state, local, apply to all persons involved in selling, buying, financing, appraising real estate, basically all parties included in a real estate transaction. So that's important to note. All right, the changes to the Code of Ethics with fair housing. Back in November, actually November 13th, 2020, the NAR Board of Directors expanded Article 10, the Fair Housing article, to include Standard of Practice 10-5 on hate speech. And what does that say? You're probably all familiar with it, but I'll read it to you quickly. Realtors must not use harassing speech, hate speech, epithets, or slurs based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. This was effective immediately back in November. Important thing, it does not have to be tied to a real estate transaction. If you've got a personal social media page and you post something on there that's hate speech, that could be the basis for a violation of this standard of practice of this Article 10. Content and intent will matter here. It is an objective point of view. I want to make sure that, these questions have to be asked, first of all, is it hate speech? Is it against a protected class? And then you have to look at the content and the intent surrounding that statement. And clear and convincing evidence is required to prove any violation, as always. The language has to be weaponized. So it's not as easy to prove a violation as one may think. You have to go through due process. You have to go through the same rigors as any other potential ethical violation. NAR is going to be coming out with some sample scenarios or case interpretations soon on this new standard of practice. And once those come out, we'll forward those along to you. Okay. A few other areas that I wanted to cover rather quickly. IAR legal forms. Who can use the IAR legal forms? Only members of IAR. These are copyrighted forms specifically for members and cannot be used by individuals that are not IAR members. They are copyrighted. It's a copyright violation and a potential damages suit or claim if someone is using these forms without the legal permission. So I just wanted to bring that up. We do occasionally get people that are handing these forms out to folks that are not members of IAR. We've even actually had a case where a third company was selling our forms. We sent them a letter and were able to recoup the damages and the money they collected selling our forms. So just to let you know that that is an issue out there. Also, just briefly, agency. In Indiana, you represent the buyer, you represent the seller, or you represent both parties as a limited agent. You have the required minimum duties under the law. We do not have a non-agency status in Indiana like a transaction coordinator. So if you're a licensee helping buyers and sellers who've basically put everything together for a buyer and seller, you're still going to be considered an agent for one or both of those parties. This is just a reminder, you won't avoid liability in that situation. So I've covered love letters, fair housing laws, the new Code of Ethics change, IAR legal forms, and some basic agency reminders. That was all I had prepared today. So I'm not sure if you all want to open this up for questions. I'll turn it back to Julie or Steve.
Can you hear me?
Yes.
It's a lot easier when you're here in person than doing all this stuff. Okay. Does anybody have any questions that you would like me to ask Rochelle? I have one, although you may not have like a long answer to this because I didn't really ask you to address it, but has there been any activity on the DOJ lawsuit with NAR that you know of?
No, I actually was just looking into that. I have not heard anything. There will be a Code of Ethics change. They're working on the DOJ settlement right now, and NAR Legal has not gotten back to us on the specific language that will be adopted. But in terms of that DOJ settlement, just as a reminder, what that settlement included was that MLS co-op commission fields must be visible to the public. MLSs can't filter or search properties based on the cooperative commission. Realtors are going to be prohibited from advertising buyer services as free. So that's going to be a Code of Ethics clarification to deal with this issue, which we don't have at this point. The NAR Board of Directors has to approve all of that. Not sure where they are at this point in time, but I'm guessing any day now. Any day now, definitely by next month, I think we should have this information. In terms of the lock boxes, and you all probably know this already, but non-MLS participants must be able to show property by having access to that lockbox. You already have the ethical duty to cooperate, so it's really not much of a change. You just have to have access to the home, not to the MLS services, okay? There's the 2 antitrust lawsuits are still out there in discovery phases. Nothing new to report, but unfortunately lawsuits take forever to resolve and or settle or get dismissed. So nothing new on that ground.
Anybody else have any questions you'd like me to ask, or you want to come up here and ask? Yes. You want to come up? Sure, come on up. It's so much fun up here. Wires, computers, wire. The microphone is like.
Okay. Well, I would just like some guidance from you when it comes to even personal social media posts that my faith is very important to me, and I do want to be careful. I would never want to come across as discriminating or hateful towards any group of people. But I think that, like, even if I just post a Bible verse, it may offend someone who doesn't agree with me. I would just like some guidance, or, you know, just help me think through from your point of view or from the legal point of view, how that can still fit together.
Sure. That, you know, in my opinion, and again, each case is a little different, and the facts and the circumstances would be looked at, but something like you just indicated would not be considered a violation. It's not weaponized against a certain group or a certain person. So there's nothing. They're not trying to go at your religious freedom. It's really basically just saying, you know, like if you said something like, that blank is not welcome in our neighborhood, that might be something, an example. A bumper sticker on a car, probably not going to lead to a violation. Again, would depend what it says. Political affiliations are not a protected class, just to let folks know that. Another example that I have would be, you know, those blanks are scum of the earth. So it's something that's weaponized. It's hate speech. It's you know, it's negative stereotyping. It's slurs. It's something you kind of know it when you see it. Okay. Hopefully that helps.
Okay.
I need to be there, don't I?
That was a really good question. Thank you for asking it. Anybody else? Yes.
We're getting a lot of transactions.
Yes.
To start with,
Yes.
who's and don'ts. I mean,
The question was, they're getting into a lot of transactional assistance for Fsbo sellers, etc. You touched on it a little bit, that agency in Indiana requires a contractual agreement. So could you talk a little bit more about what that looks like when someone wants to assist a seller or buyer with paperwork?
Yeah, and as I indicated, if you're assisting someone with paperwork, there's still going to be an implied agency relationship, whether you have anything in writing or not. The courts are going to imply that. We don't have, like I said, a non-agency status if you're a real estate licensee helping a buyer or seller, so you're going to be considered an agent. So once you do get involved, even if it's at the tail end, you still have to make sure that you're satisfying your duties, that you're exercising your fiduciary duties to that client. Okay. Hopefully that helps.
Facilitating?
Would you be a limited agent if you're simply facilitating?
Yeah, we don't have transaction facilitators as a legal status in Indiana. Some states do, we do not. So you cannot, you can't just act as facilitating a transaction without being an agent. And yes, you might be an agent then for both parties. If you are representing a buyer and a seller and just concluding the deal, then you'll likely be seen as an agent for both parties, an implied agency. So just be careful about that. So if a seller or buyer wants to sue you down the road, they're going to say, no, they weren't just facilitating, they were an agent, because we don't have a non-agency status in Indiana.
Yes.
Julie, we can use our ordinary document. All right.
But I'm sorry, what about those?
Use those, right?
Well, I think she's saying that you aren't really going to be able to coordinate without being an agent. And if you are an agent, you're absolutely able to use those forms, yes. Not that I'm speaking for Rochelle, but.
Oh, that's okay, Julie.
I guess. Sorry. Any other questions? Yes, Mary.
I asked you about the farms that are for sale by owner, like they match at our
Yes,
counter.
yes, yes, yes.
So nothing can be done about that, right?
Only if you know who supplied them, then I believe IAR can write a cease and desist letter and take steps.
If you're aware of someone using our forms or providing our forms to someone that's not a member, we have a cease and desist letter that we'll send out to that company or that person to let them know that these forms are copyrighted, they can't be used or provided to folks that are not members, and that it's a legal violation if that happens. So that way, put them on notice, and generally that nips it in the bud at that point. Are you guys having any issues with escalation clauses, multiple offers? This is such a hot market. We get lots of questions on those. I see someone just put something in the chat. Representing a buyer with a Fsbo. Okay, so this is actually a good question. We do have a Fsbo compensation agreement, so you could represent a buyer, have that form signed by a seller, and you're only representing the buyer. And that form specifically states, I am only representing the buyer. Seller, you're selling on your own, I'm not representing you. So if you use that IAR form, you're protected. You will not be a limited agent. You will just be representing the buyer. Okay, thanks for the question. And escalation clauses, just to kind of give you a heads up on this, we get a lot of questions on what happens if you get identical escalation clauses. You know, what do you do? Well, generally, you're never going to have an identical offer with the same terms and conditions. You know, so the time to close or the type of financing, deadlines, those will likely be different, even if the escalating factor amount is the same. So, and does a seller have to accept an escalation clause addendum? They don't. They can just counter back at whatever price they want and not utilize the escalation clause. So that is up to the seller. But the buyer agent does have to provide that as part of the offer to the seller or the listing agent.
Karen?
In regards to the escalation, when you do escalate an offer, you have to provide documentation to that person in a counter offer and provide the offer that escalated it. Do we redact?
Yes.
Out some of the personal information?
Yes, you can redact any personal information. You know, if that documentation is required to show someone, yes, I did have a genuine bona fide offer that kicked in the escalating factor.
To repeat Karen's question? Sure. I believe Karen was talking about having an offer with an escalation clause and something else came in that bumped the escalation. So do you provide that information to the second person coming into this situation? I don't know anything about escalation.
Yeah,
do you remove the personal information to from the purchase agreement that escalated the offer and the information? And she said, yes, you redact the personal information. Is that right?
Yes, yes, that's right. You can redact that information so that buyer it can be proven that there was a bona fide offer that kicked in that buyer's escalating factor. So also a good thing to know is the purchase price, if an escalation clause is used, is not effective and not binding until the seller sends back a counteroffer with that escalation clause addendum, and then it's signed by the buyer. So until you have an official agreed upon purchase price, it's not binding. So that's important to know.
Mary, or Mary's table?
What if the listing agent never sends the escalating offer, but the buyer would sign it, they want to make it small. But then they're never provided the offer to escalate, the entire offer. I'm not talking just the first page.
Can you hear that, Michelle?
I could not hear that. I'm
Can you
sorry.
maybe repeat? Because I'm not, this language is like Russian to me.
So the question was essentially, if you submit an escalation clause, does the listing agent then have to send back proof, basically? Am I understanding that right? They have to send back the purchase agreement. And what if they don't send back that purchase agreement showing why it was escalated to a certain amount?
Yeah, that really needs to be asked by that buyer. So it's not automatically provided. You know, a copy of another offer is not going to automatically be provided to a buyer unless they ask for it. So that buyer is going to have to ask for it. If they counter back and they have the escalation clause addendum and a counter going up to the buyer's cap, and they say, hey, how do I know that this isn't fraudulent, that you really had another offer? Then the seller provides the redacted offer to that buyer to show them that they're acting in good faith.
And not just page one, it would probably need to be the entire purchase agreement because of further conditions.
Well, yeah, probably. I mean, you could, you know, depending on what else is in the agreement, you know, the purchase price may be sufficient. But generally, it's going to be more than that.
I don't know why the buyer has to ask for it. It says right in there that it will fix the
Yeah.
the copy of the completed offer.
So the
Why
question
does the buyer
is,
ask?
does the buyer have to ask for it? Shouldn't it be sent automatically?
That's what the escalation clause is.
It's, you know, the seller could just go ahead and send it automatically because most buyers are going to say, hey, well, I want proof. There was another offer that kicked in my escalation clause. So to shorten the transaction, if I were the seller, I'd go ahead and provide it. But, you know, if they don't, then then the buyer's going to have to ask for that.
And just on my behalf, to make sure I'm understanding correctly, the seller doesn't have to use that escalation clause. The buyer is basically showing their hand. If they say, hey, here's my escalation clause, the seller can come right back and counter at that maximum dollar or any dollar amount that they want to, and they don't have to furnish proof. At that point, they're just countering the offer.
That's exactly right. Yeah, they do not have to use the escalation clause. Now, one important point is there is a cap. There is a language that has a cap. That doesn't have to be used. Generally it is, because a buyer doesn't want to wind up paying too much for the property. But if you do put what, you know, the cap, the maximum amount you're willing to pay, then obviously the seller knows what you're willing to pay and they can just counter back at that amount and not even use the escalation clause. There are folks that don't put a cap in there, you know, then you might run into an appraisal issue down the road. But that is, again, up to the buyer whether they want to put a cap in that escalation clause addendum.
Have there been any issues in the state about the list agent representing a buyer and then the escalation clause coming into play where they have all that information?
That's a really good question too. The question was, have you seen anything at the state level where the listing agent is also representing the buyer who's using this escalation clause and therefore has full knowledge of buyer situation?
Yeah, and that's a tough one. Yeah, they absolutely can be on both sides with the escalation clause. So you have to be really careful since you're representing both sides of that transaction. Again, the buyer doesn't have to use an escalation clause addendum. The seller doesn't have to exercise that escalation clause addendum. And nothing is binding until that seller sends the counteroffer back with the adjusted purchase price and the buyer signs it. So until that buyer signs that, they can still basically back out of what they put in the escalation clause addendum.
Right. As soon as the seller makes a counteroffer, it's still on the table until that buyer signs. Okay.
Exactly.
Anything else? Yeah. Go ahead, Pat.
So cases where there's about 25 offers, that is the escalation clause. Sign escalation clause. Offers. So the sign is the same.
That's a good question too. So the question now is, in situations where there's multiple offers, 10, 15, 20, whatever it may be, does the seller need, if they reject offers, do they need to sign on the escalation clause, noting that they've seen the escalation clause and send that back with their rejection of offer?
They don't, well, I mean, they don't have to. If they're rejecting the offer, that's part of the offer, so they're rejecting it. So if I understand the question right, I mean, you certainly could. I mean, you know, to dot all I's and cross all T's, that there's no harm in doing that. But I mean, if you're rejecting an offer from a buyer, then any part of that offer is going to be rejected. Okay.
Well, because I had some other agent that said back to it, I need to, I have to have escalation clause signed. If you speak out of that, was another agent who wanted escalation clause.
Sounds like it's a seller option, I believe, Chris. Yeah, I think it's definitely a best practice to have them at least initial it, acknowledge that they've seen it, so they don't just get the rejected, you know, page 8 purchase agreement, and there your buyer wonders, my goodness, did they even see my escalation clause? I know I've gone so far as to merge those documents and create one file out of them because I want to make sure that that didn't get lost in transit.
Yeah. Well, and if you put in the purchase agreement somewhere under further conditions, see escalation clause addendum, then the seller's going to be aware of the fact that that is attached or should be attached. Okay, so that's a way to potentially deal with that. You also have the right, you know, to make sure that your offer has been submitted to the seller, and that the listing agent then has to admit in writing that, yes, I have forwarded your offer to the seller.
There's a question online there. I don't know if you saw that one from Annie Logan.
Yes, Annie is asking, I've had a seller want to counter above the list price and above the escalation cap with multiple offers. Are there any ethical conflicts with that? Not really. I mean, the only issue would be, is the property gonna appraise for that? If it's a cash sale, then it may not matter because the buyer obviously is gonna pay whatever they, you know, whatever they're comfortable paying. But you're asking here if a seller wants to counter, they can. I mean, they certainly can, but again, they're going to have issues with the property being able to appraise for an amount that's so high. You know, if they've got a cash offer, then that may not be an issue. But I would just make sure the seller's aware of the financing issues if they go too high above what you think the property is worth.
I hope that answered your question, Annie, and I hope your dog's got a snack earlier too.
And it's, I mean, it's happening. You know, what great problems for you guys to be having right now. Honestly, I know it's stressful, but at the same time, this is great that you've got, you know, people, property.
Any other questions out there or online? I think we're safe for now.